Thank you so much. Again, my name is Frederik Harhoff. I'm Professor Emeritus of International Law at the University of Southern Denmark. Today I wish to speak about the law of treaties. And you may recall from our first session that the sources of law are the laws that apply to international courts, basically, but also in the interplay between states and other legal subjects of the international legal system. Treaty is a written agreement between states and sometimes also between states and international organizations of states, and sometimes even between international organizations as such. So a treaty is an international agreement in writing. And the way in which treaties are concluded is described in the Vienna Convention on the Law of Treaties from 1969. It's a UN treaty that defines and spells out exactly how states are supposed to go about the conclusion of a treaty. Treaties are normally negotiated between the states that are willing to become partners to the treaty, the signatories as we call them. And so the normal course of the making of a treaty is that either United Nations or some other international organization will call for a conference in which states are invited to join in order to negotiate an agreement on some particular topic, be it on the law of the sea or environmental pollution or whatever subjects, economic translations and so on and so forth. So all states who are interested in taking part in these negotiations will then send delegations, either to New York in the headquarters of the United Nations or in some other states that assumes the hostship of the negotiation of the treaty. These negotiations will then take place regularly, normally once or twice a year. All nations, all states will send delegations consisting of anything between 2 and 5 or 10, sometimes even up to 30 people. And they will all travel to the place and they will meet up with colleagues from other states and begin their negotiations. Then the chairman is appointed of the conference, and the chairman and the secretariat will then be the formal leaders during the negotiation of this treaty. So normally we begin by negotiating the title of the treaty and what are the main rules. Then we normally split up. Some working groups will then be established among the members that have shown up for the negotiations. And one group will be asked to provide the initial rules, the preamble of the treaty. Another group will be asked to come up with the formulas for some of the material norms of the treaty. Others will be asked to define which parties can be adopted in this treaty. For instance, as we just had the example, can Taiwan become a separate member of the treaty or not? So these things are all questions that need to be negotiated. And so the normal course of the making of a treaty is that the conference is called over the period of 3-4 years sometimes. Sometimes it's shorter depending on the number of countries that are invited. If it is only a bilateral treaty, then of course between 2 states only, then it will be faster. But a multinational treaty that is negotiated on the international level is normally stretching over a period of several years. And then towards the end, finally a text is adopted, accepted by all the members who have negotiated the treaty provisions in those years, and they end up by adopting a text which is the final product of the conference. So after all these states have negotiated for years and years, they end up agreeing on a draft. And that means that once they have agreed to this draft, no further amendments are possible. So that's the end of the negotiation process. And from that point on, most of the states will have to go back to their home countries and then seek whatever parliamentary acceptance of the treaty may be necessary. This is what we call the ratification procedure, because when the negotiating team comes back from the place where the treaty has been negotiated, comes back from the conference, it is obvious that in most cases that all states need to introduce new legislation in order to be able to fulfill the requirements of the treaty. So in Denmark, for instance, if the Danish delegation comes back, it will present to the Minister of Foreign Affairs and to the Parliament that we need to introduce these 5 or 6 amendments to Danish law, or maybe introduction of a completely new parliamentary act, in order to be able to meet the requirements to become a member of this signatory to this convention. That takes another half year, or maybe 1 year, depending on the problems that are lined out. If it is a very complicated process, then the Parliament may wish to discuss this at length until finally consensus is reached in Parliament that yes, we will accept to introduce these amendments to Danish legislation, and so we can finally ratify the treaty. When all the necessary domestic amendments have been made to domestic legislation, then the country is able to ratify the treaty. And that is done through an instrument of ratification, which is a big page, basically, that says that from this moment on, Denmark accepts, if it is a Danish ratification, accepts the terms and conditions of this treaty, and hereby notify the international community that from this day on, Denmark will see itself as being obliged and performing the duties and also enjoying the rights under this treaty. And then it has to be signed by the sovereign, the head of the state. So in Denmark, this is a kingdom, so we have this instrument of ratification signed by the Danish Queen. And then this document is brought back to the place, to the city where the conference took place and where the treaty was negotiated. And then it is kept there in the archives of the secretariat that was leading the negotiations. So from the moment where the Danish instrument of ratification has been delivered in the capital of the country, then from that moment on, Denmark is officially able to enjoy the privileges and also obliged to abide by the duties. So each treaty then consists of basically 3 parts, namely, first of all, a preamble that sets out the purpose of the treaty. And then in the middle, you have all the substantial rules of the treaty. And then in the end, you have the regime of the treaty, the so-called the treaty regime. And that is a number of provisions in the end of the treaty that spells out how many countries do have to ratify before the treaty can enter into force. And what about reservations? Can state make such reservations? And when exactly can that be made? So these 3 parts are then, you can find them in all treaties. You start out by the preamble, then you have substantial rules, and then in the end you have the treaty regime. Finally, I would like to say a few words about the interpretation of treaty provisions, because the main rule in the law of the treaties is that the treaty provisions have to be interpreted in conformity with the purpose and the formulation of the treaty. That is a soft formulation, but it means that if a state wants to apply an interpretation of a treaty provision that is completely contrary to the wording of the particular provision, then states who are interested can then bring that country before a court, perhaps if there is a court procedure available in the treaty, and then claim that the way in which the country here is interpreting this provision is in contravention and contradiction with the purpose and form of the treaty. So thank you very much. This is as much as I will say for now about treaties.